input for the people. Your Honor, the people would waive any potential conflicts between this honorable court and the office of the public defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
Good morning, everybody.
Good
morning, Your Honor.
You're
Joy
watching
Gaines,
Live
your
with
Assistant Public
Cowboy,
Defender.
and we
Your
are
Honor,
in
we
court
too do not
morning.
believe that there is any conflict. But
Judge
if there is a
Simpson.
conflict, would waive all conflicts.
And it looks like he's got a full docket for today.
Michigan court rules. Other cases decided
So
they were under
we're going to watch together.
extent a conflict does
Feel free to
exist, given the
throw
waivers,
comments
the
in
court
the
will
chat,
send
like and
to you
subscribe to
later.
help support the channel.
What time did I
And
enter?
That's now
let's see if he's
9:20.
got anything interested today.
9:22.
9:22.
I'll shut up so we can get some listen.
Oh,
I just want it on the record.
Oh man.
Okay, she said 9:20. 2 minutes late.
I will be
All right.
watching the chat.
Court does
And
call
I
the
will
case of
reply
the People
right
State
back
of
to you.
Michigan versus Anthony Charles.
So
Jacob Kennedy for the
feel
people,
free
Your
to
Honor.
type away. All right, here we go.
Good morning, Your Honor. Under Tanazi Kyriakin-Ruli, on behalf of Mr. Anthony Holston, should be appearing from MDOC Judge.
Yes, he
It's gonna be
is,
a
and I have
great
to start my
day.
day with you.
It's gonna be a great day, Judge.
Yeah, I can feel it. Mr. Holston, can you state your name, please, sir?
Anthony Holston.
Thank you. I have before me a plea form that indicates that the defendant is going to plead to the charge of aggravated assault, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement, and there should be a sentencing judge waiver. Or no, what are we?
Yes, Judge.
Well, that's okay. The boxes are checked, but it's not my case. All right.
And this should
Just a
be a
quick
no
audio
contest
check.
plea. Is that right, Judge? Do you
Under
have?
contest. All right. Mr. Holston, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth? Hope you got.
Yes, sir.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. Do you understand what a no contest plea is, sir?
Yes.
My mic
All
was
right,
just
two things
muted.
about it I have
That
to make
was
sure that you
probably the
understand. The
loudest
first thing
thunder
is-
I have
Is that
ever
it
heard.
first of all means that you're not further desirous or wanting to contest this
pouring
charge. You
outside.
understand that?
Harley,
Yes.
Second thing you need to
Okay,
understand is
puppy.
that for purposes of sentencing,
Oh,
the
it
court is
scared the
going to
big
treat you
guy.
the same as though you had pled guilty. You understand
It's
that?
live
sir?
with Cowboy, but
Yes,
it's
sir.
also live with Harley.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced
Scare you?
before Judge Perry in the 15th District Court.
It's
Okay.
You understand that?
Yes.
I know.
Right. Basis for the no contest plea?
Lack of recollection, Your Honor.
All right.
That thunder scared you, didn't
To
it?
that charge, sir, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
All
Papa's
right.
got
You had signed or had signed on your
That
behalf
thunder
an
ain't gonna
advice
hurt
of
you.
rights form. Is that correct?
Yes.
Any questions regarding any of those rights?
No.
You understand that you're giving
Papa's
up all of
got
those
you.
rights, including the rights contained under paragraph 5.
Yes.
You understand you're giving
don't
up your
like
right
that
to
thunder,
appeal
do you?
of right.
Yes.
It's okay.
Are you on probation or parole?
No, sir.
Okay. Papa's got you.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Sorry,
Anybody
guys.
threaten you or coerce you in any
Harley
way?
is not a fan of
No.
thunder, and it is.
You're doing this
thundering.
voluntarily and of your own free will?
Yes.
Court has been provided Ann Arbor
160-pound
Ann Arbor
dog,
Police
absolutely
Department report for their
terrified us
case
of
number
rumbling thunder.
24-61658.
him.
Any
It's
objection
loud.
to the court having reviewed that report?
No, Your Honor.
From defense,
Papa's
Judge.
got you.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
You guys can't see, but
Is
he's got
counsel
his
aware of
head-
any other
he's-
promises,
he's
threats, or other
over my
inducements
chair.
that have led to this plea?
Your
And
Honor.
his head is resting.
have I complied
on my
with the
hand
court?
on the desk?
Defense is satisfied.
Court will accept the defendant's no
It's
contest
okay.
plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing
What'd you
will
do?
be
July 17th at 8:30.
July 17th, 2026, 8:30 before Judge Perry. Bond will continue.
Thanks, Your Honor.
Thank you. Thank you, Mr. Olson.
So it's always nice and easy when he pleads guilty immediately.
Oh, good morning.
He didn't seem like a happy
Court
individual
calls
today.
States People versus Stephen Huska. I heard what Ann,
So Your Honor.
I heard what Ann was saying.
Jessica McFarland requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public
Man,
Defender
that looks
Michael
like a
Gattney.
full docket today. I like it.
Really?
Let's hope for some good ones.
How is he as a supervisor?
Hmm.
Yeah, okay. Permission
I
to
got you,
practice is
baby.
granted.
It's okay.
Wow.
Brother, friend, I get that same review.
Yeah.
We have the defendant state their name.
Huska? Oh, they're in there doing it now. Thank you, officer. Mr. Huska, state your name, please.
Steve Haska.
All right. And what are we doing?
We are requesting to adjourn for further negotiations with the people.
Do we have a green sheet?
Yes,
It's gonna hold it.
sorry.
Eddie tape.
No,
Let's see. July 9th work.
Spit everywhere.
Yes,
big
Your Honor.
guy.
Matter will be adjourned without objection to July 9th, 2026, 9 a.m.
thank you, Your Honor.
If you're just joining, welcome to Live
continue.
with Cowboy. We're
Thank you.
watching Judge Simpson on his docket for today, June.
Court does call the case of the
18th,
people versus Sarah
2026.
McCormick.
Good morning,
Please
Your
like and
Honor.
subscribe to
Andrew
the channel.
Cito, PH 7447
Help
on behalf
support
of
me.
defendant Sarah McCormick.
Mr. McCormick, can you unmute? State your name.
Hi there. I'm Sarah McCormick.
Thank you. All right, what are we doing?
Good morning, Judge. I spoke with the prosecutor, and me and the prosecutor have been working together, and she offered me a deal to reduce this down to a misdemeanor for controlled substance use. I haven't had the chance because we just spoke with the prosecutor yesterday. It was pretty late, and so I just need
So
to.
you did an adjournment?
Yeah, just an adjournment so I can just go over this with my client and then come back here
Right.
for the conviction.
Will July 2nd work?
Yes, Your Honor.
Probable cause conference will be adjourned July 2nd, 2026, 9 a.m. Bond continued. Thank you, Ms. McCormick.
Thank you.
Court calls the case, People versus Matthew Kennedy.
Good morning, Your Honor. May it please the Honorable Court, David Burgess, on behalf of many.
Her name, sir?
Matthew Kennedy. Your Honor, we are asking for an adjournment of the probable cause conference. My client did complete Bear River and it might work into the plea, but the prosecutor needs the proof of that, so I need to get it from my client.
All right. Couple of work.
Yeah, I did want to address bond if we could just briefly.
I'll adjourn these matters to July 2nd, 2026, 9 a.m. As the bond.
Thank you, Your Honor. Judge, my client failed to appear on a date. He had called me later that day, got his dates mixed up. Tried to walk him in on a Wednesday, but he was not able to meet me at the one Wednesday. I was able to do it that day, but did complete Bear River, Judge, and he did contact me. These aren't assaultive cases. I understand the concern the court might have, but does have stable residence area, and I think he will return, Judge, based on.
So how do you come into custody?
I don't. How'd you get?
I was at work.
You
picked up at work.
Yeah, picked up at work.
They just came and got you?
Yeah, I didn't cut my tether off or nothing. I didn't like abscond. I didn't.
He had a tether on, Judge. I mean, yeah, it's pretty easy to find, I guess.
Yeah,
So,
it didn't die or nothing. I kept it charged. I kept doing my weekly check-ins. I kept going.
Why was the first thing that came to your mind cutting off your tether?
no, he said he didn't
I
cut
thought
off.
that-
No, I know he didn't say it. Well, why did that come to mind? Never mind.
Cause I didn't,
It's context, Judge. That's all
It's
it is.
just context.
yeah, like I wasn't trying to go on the run. Oh, sorry.
You're good.
Anything from the people on the,
No, you're wrong.
all right. What I will do is I will reinstate the defendant's previous bond in this matter.
Thank you, Your Honor.
All right, thank you.
You want me to change my mind?
You want me to change my mind?
Sometimes it's
No, he
better
said thank
to
you.
just.
Oh, I
Shut up.
know, I know what he said. If it doesn't go, I'm gonna change my mind.
Leaving quickly.
Yes.
Mr.
Court does call the case, People
Anderson.
versus Robert Anderson.
Throw in chat if you know what that's from.
Your Honor.
Good morning again, Your Honor. May it please this honorable court, David Burgess, on behalf of Robert Anderson, who's appearing via Zoom, Your Honor.
Hello, Robert Anderson.
Okay, thank you. All right, what do we do?
Your Honor, the people have indicated to me that there's some additional discovery we're going to have to review and obtain prior to the exam, so we're requesting another adjournment of the probable cause conference.
How much time are you gonna have?
Should be not this, a couple reports from YPD.
All right.
Which is fine, Your Honor.
Probable cause conference, July 2nd, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Court does call the case of the People versus Charles Johnson.
Your Honor, as well as the people.
Oh, on behalf of Mr. Johnson, who'll be approaching the podium and standing to my right. Mr. Johnson, once you get up here, please state your name for the record.
Is that supposed to be her case and you took it, Feltes?
Yes, Your Honor.
Lady, where are you from?
Lady, where are you from? Okay, don't let her do that to you. Huh. All right, go ahead. I'm sorry. Your name, sir?
Charles Bernard Johnson II.
And Your Honor, at this time, we are asking that the matter be set for exam.
Discovery is complete.
To my knowledge.
What would it be?
We are on June 30th.
People have their witnesses available June 30th? All right. Preliminary examination will be set June 30th, 2026, 9 a.m. before Judge Washington.
Thank you.
Bond will continue. Thank you. Court calls the case of the People versus Amanda Brown.
Your Honor. Written.
Morning again, Your Honor. May it please the honorable court, David Burgess, on behalf of Amanda Brown, who's approaching.
Your name?
Amanda Brown.
All right, this is a waiver.
Yes, Your Honor.
Ma'am, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand that you'll not have that hearing. You'll proceed to circuit court for further proceedings.
Yes, sir.
People also waive their right?
Yes.
Yes.
Not that official offender notice as well as an agreement. My understanding is that it's currently on probation circuit court. There would be an agreement to have her at concurrent probation, no upfront jail with her parents.
That's our understanding as well, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Burgess.
Waive formal reading, stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 11th at 1:30 with Judge Cunty.
August 11, 2026, 1:30.
Okay.
Bond continued.
I'll call you.
All right, I'm done.
Court calls case of People versus Douglas Hill.
Over for the people, Your Honor.
And Assistant Public Defender Zach Venue with on behalf of Mr. Hill, who approaches on the case ending in 163.
Morning, Your Honor. Jay Grant, Miller, P58658 on behalf of Mr. Hill on 2111.
Douglas Hill. Thank you. Both of you are requesting an adjournment.
Your Honor, yes, we're trying to keep the cases together, and I believe I spoke with the prosecutor this morning, and she's still waiting on a CCTV video. And as soon as that happens, we'll set for exam.
How much time are we going to need to get that?
Spoke with the agency yesterday. They indicated that it was just processing.
It was on,
The request, they had uploaded it, but it's processing.
Got it. So a couple weeks, you think, gentlemen?
I would defer to the prosecutor, Your Honor.
Pardon?
Good here.
All right. Probable cause conference will be adjourned to July 2nd, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Morgan. Is it G-Lander?
Morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Morgan Jalander.
Your name?
Morgan Jalander.
You're requesting an adjournment?
Yes, Your Honor. 2 weeks is okay, Judge.
Your work.
I think I'm,
Probable cause conference will be adjourned July 2nd, 2026, 9 a.m. Bond will continue.
thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Safara Kent.
County for the people, Your Honor. Michael Gabby, Assistant Public Defender on behalf of Mr. Kent, who's approaching, Your Honor. State your name for the record. State per count.
You're requesting an adjournment. Will 2 weeks be enough?
Would that be enough to get them?
Oh, you need,
Your Honor, I believe there's some additional charges coming.
That is correct.
So I don't know if they'll be able to get them arraigned on those, but I would think 2 weeks, depending where they are in the swear to process.
My understanding that's where it's going to take place this December. So
okay, is he then set to be, the swear to will happen, is he set to be arraigned this afternoon?
that, no, Your Honor, just swear. That's correct. Or 3 additional.
Gotcha, okay. And so that this wasn't on where the officer was on call.
No, but for this.
Got it. Okay, so that's where two is gonna take place. He would then have on those charges. I don't. You want me to put it out 2 weeks or 3? Because here's the reason I'm asking. I don't understand if the swear to is gonna happen. He's in custody. I don't know why we couldn't add him to the list to have him arraigned on those 3 charges this afternoon and then set it 2 weeks out. But if you don't want me to do that,
That's fine with us, Your Honor.
all right.
I am correct. Word too about what exactly is going to happen this afternoon. That maybe they can get them on the list to be arraigned as well. Certainly.
Zach Ward's involved.
Not. You know,
If he's involved, this isn't gonna happen.
I'll make sure he knows that.
All right, so if the officer's gonna swear it out today, we communicate with the magistrate to see if they can get him arraigned and then set it for the 2nd? So I'll adjourn this out, probable cause July 2nd, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case
Sorry,
People
I was
versus
playing
Dominic
with,
Brewer.
Video.
Morning, Your Honor. My name is Cook for the people.
Good morning, Your Honor. Cowboy on behalf of, but not with Mr. Brewer. Your Honor, it's my understanding that Mr. Brewer was picked up in Canton yesterday. Because of a hold that he had already. So I think it's my understanding, I believe he's in the Wayne County Jail or in the Canton lockup. I spoke to a family member yesterday late.
Well, we have. Yeah. We have it. That yes, he was picked up. And they filed. A conditional bond violation.
All right. Okay. Thank you. I wasn't aware of that bond violation, so thank you for that. Your Honor.
Yeah, this is the report. I think this is the Canton report that they then filed with this court, took him into custody down there.
Understood.
So at this point, what I will do though is I'll issue a bench warrant for his failure to appear. That way we can go get him. Bond will be setting him out of 10,000 cash surety.
Thank you, Judge.
You. Court does
Well,
call
there
the
you go,
case of
folks.
People
Don't show up to
versus
court and you
Lorenzo
get bench
Murphy.
warrant.
Great, the people, Your Honor.
Go figure.
Good morning, Your Honor. Police Honorable Court, David Burgess on behalf of Lorenzo Murphy. Your Honor, we're asking for an adjournment of this matter. I just got this case. I was just appointed on it.
Are you on both cases?
Yes, Your Honor.
Need 2 weeks,
Yes, Your Honor.
July 2nd, 2026.
Wow.
Any
Reach out.
bond continue.
Thank you.
Thank you, sir. Court calls the case of the people versus Daryl Howell.
People. Good morning, Your Honor. Nathan Coulter requesting to
What?
Michigan, Michigan, Michigan.
I have no
Okay,
idea. what
permission to
that guy
practice
just
is
said.
correct.
Edward Rodriguez on behalf of Daryl Howell. Your Honor, I just was appointed. The contact information is not good. I don't have an email. I'd asked for an adjournment just for purposes of contact with him. I do have an address. I did mail him a letter yesterday, but I haven't got any confirmation back. I know he's on probation, Wayne County.
He's on probation in Wayne County?
On probation in Wayne County. So in the event that I reach him, if the court were to adjourn it, this is the first PC.
I understand that, but I think, given the nature of the charges, I'm going to issue a bench warrant for Saturday to appear.
Pretty simple,
Bond will be
folks.
set him at a
If
10,000.
you show up
cash
for
surety.
court,
Thank you. We'll issue immediately. Thank you.
you don't get a bench warrant.
Court does call the case, people versus Christopher
I
Madison.
don't know. I guess I'm the only one that makes sense to.
Over to the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Madison.
In both matters.
In both matters, Your Honor.
Your name, sir?
Christopher Madison.
Thank you. You're requesting an adjournment.
Well, Your Honor, I did attempt to go speak to Mr. Madison yesterday. He indicated he may not want the services of the public defender anymore.
Why
So-
would you?
What? He doesn't want the services of the public defender?
I'm
gonna
Why
hire
would
his
you
own.
want to get rid of your
No,
public
I-
defender?
Go ahead.
to a letter and I pleading guilty on all charges, sir. So I figured I
Oh,
didn't
he
need
just
a
wants
public
to plead
defender to
guilty.
plead guilty.
Okay.
Why wouldn't you at least?
Mr. Madison,
I mean, props for owning what you did,
did I receive this letter? I don't think so.
but wouldn't
I
you
don't-
want a shot?
Yeah, I don't know that I've received a letter from you.
Oh,
And why do you want to plead to 2 felonies?
because I'm
5 years.
sir, I was
Yeah,
under the influence of
yeah.
drugs.
Okay, hold on. I don't want you to, well, just listen to this, Mr. Madison.
Uh,
I don't want you to say anything about the charges,
okay.
okay?
Yeah, even Judge
I'm
Simpson
just
doesn't
trying to
even
figure
understand.
out why you want to proceed in that fashion, but hold on a second, Mr. Bukovich.
Your Honor, as I said, I don't want my client to put anything on the record that could incriminate himself. Obviously, he cannot plead at this stage. We're at the PC stage, which you cannot plead to a felony at the PC stage because this is a.
Oh, you can, yeah, I don't take the plea.
You're not going to take the plea. So ultimately, I believe at this stage, our best option would be an adjournment for us while to have time to consult with our client about the implications of a plea.
Let me ask you this, sir. You're trying to get this done with.
Yes,
Okay.
sir. I'm trying.
Okay, hold on. It's not gonna happen however it resolves itself. It's not gonna happen less quickly or more quickly if you have an attorney. Right?
Okay.
So I don't know,
Of
I
course
think
it's in
having the
its
public
interest.
defender is in your interest. The important thing, more so than it being quickly, is that all of your rights as you go through it and you go, whatever your decision is, your decision. But that to make sure that all your rights are protected. That's part of the reason that they're there and that your interest is protected. Okay? So I think what you should do, I'm going to adjourn these out a couple weeks, okay? And then let you talk to the public defender, tell them what you want to do and talk it through with them. Okay, fair enough? Okay? All right. I'll adjourn these to July 2nd, 2026, 9 a.m. Thank you, sir.
Thank you, Your Honor.
Court case, People versus Deontay Jordan.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. J. Grant Miller, 58658 on behalf of Mr. Jordan. Your Honor, I was communicating with my client last night. He indicated having some transportation problems. He lives in Lansing. I encouraged him to get the bus down here. I would request
a whole bus thing, but go ahead.
Well, I did suggest the flyer does travel from Lansing to Ann Arbor, and then he can get the number 4 down here. Literally, I texted that to him, Your Honor. Not here. I understand the people are probably going to request something.
Bench warrant will issue for defendant's failure to appear. Bond is set in amount of $10,000 cash for surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Jason Smith.
Ready, Your Honor. Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. James Spifelski appearing on behalf of Jason Smith, who is approaching. Can you please state your name?
Jason Smith.
Thank you.
Your Honor, this is our first PCC. I'm asking for an adjournment for discovery and investigation on this, please.
July 2nd, 2026, 9 a.m. without objection.
Thank you, Your Honor.
Bond continues.
Thank you, Judge.
Court calls the case, People versus Janine Lebrel.
Morning, Your Honor. Raymond Cook for the people.
For the record, Your Honor, Stuart Collis on behalf of Ms. Lebrel, who is approaching and coming to my right.
Hello, your name?
Jean Lebrel.
It helps to have some light on.
Your Honor, today for
I
PCC,
forgot
we
about
are
that.
asking for an adjournment of this matter
Sorry
to do
about
some
that,
further
folks.
discovery. There's some videos that we need as well as some negotiation in this matter.
Probable cause conference will be set July 9th,
Very well. Your Honor,
26,
I
9.
have a brief request on the bond. My client has to go out of state for her nephew's birthday in Columbus, Ohio. And while I am sad that
To Ohio?
I know, right?
No, go ahead.
It's late June, and she obviously will be returning back where her partner home is, but
Do we have travel dates?
yes.
Yeah, it's the last Sunday in June for my nephew's first birthday. And I'll be staying with my parents.
So the 28th,
The intention is to drive down on the Saturday and then come back the Monday.
Saturday, 27th.
so 27th to the 29th. Any objection from the people?
No, Your Honor.
All right. Her bond will continue. And you get me, you're doing it. And then I will allow her to travel
To Ohio.
to Ohio for those 3 days. Enjoy.
Thank you very much, Your Honor. See you on the 9th. Thank you.
I'm sorry, Miss Enda.
I'm so sorry you're
I'm
from
really
Ohio.
sorry that you're from Ohio. Court calls,
That's nice to say.
court calls the case, People versus Wardell Smith.
Your Honor.
Morning, Your Honor. Robert G. Kill on behalf of Wardell Smith.
Much better person having been in Michigan, but
Today's time for PCC.
your name, sir?
I'm sorry. We set this for exam.
Discovery is complete.
Yeah, it's a reauthorization. Everything's the same. Yes.
All right. People have their witnesses available the 30th.
We'll do our best, Your Honor.
All right. Preliminary examination will be set for June 30th, 2026, 9 a.m. before Judge Barr.
Judge, may I make a bond argument?
Ma'am.
Judge, because this is reauthorization, the victim, who is the mother of his children, never showed the first time. That being, pardon me? His wife, I'm sorry, his wife. Since he's been in jail, since April 21st, he's done 3 weeks of Dawn Farm program. He could do that outpatient. He's also continuing with CMH. He could do that outpatient. done a lot of really good programs in the jail, 12-step, the DV1, DV2. I know what the prosecutor is going to say, that he called the FBI. He admits he called the FBI. He was worried about his children. After he called the FBI, his son then called him, say, "Dad, everything's okay." He tried to cancel the FBI appointment. So again, it wasn't.
But that, I've heard this before. It wasn't just the call to the FBI. There were other calls that were also initiated by this defendant regarding police involvement.
Careful, what do you want to say? It was for the benefit of your children? Yeah, Judge, he did call, what, Pittsfield?
Yeah.
He did call Pittsfield. Again, it was concerned about his children, Judge. Again, there's a serious charge. We understand that, but my client could live with his mother in Ypsilanti. She's already said it's okay for him to live there, even if it were on tether. The other issue is, Judge, and I know this really doesn't go to the case, he has a lawn business that all his equipment is in a storage area that's about to be repossessed and sold out. And we're asking the court to please consider just a reasonable bond for this man. He will stay away from the victim. And the calls he made were for the benefit of his children, who then called Dad and said everything's fine so far.
Once again.
I'm gonna object. While the defendant may say those were for the benefit of those children, some of those calls that involved him reporting a shooting, having law enforcement respond to that house where those basically, in a sense, swatting that residence for a shooting that did not occur. Beyond that, he did call the FBI, and there were also allegations of drug use while he was out on bond. I also have concerns given in one of his calls on the 15th, he mentions, "I want to know if you can help me get back to good graces with my family, that I have a child with my wife. Tell her not to cut me out of the picture. Tell her that I still love her and I need her back now. I need some support." So I have concerns that he has shown this court time and time again that he cannot follow bond and is a danger to not only the victim, but the community and law enforcement by abusing their resources and having them to respond to things that are not happening, and also harassing this victim. And I mean, at this point, it was reauthorized because she came back around and was on board, because she was in fear for her life because of this defendant. So I think at this point, bond is appropriate, given that he has shown this court he cannot follow the orders of the court, and is still even now attempting to try and get a hold of this victim, along with calling her directly, having other people in his family reach out to her.
That's what I was trying to do.
Judge, he said he was never trying to get a hold of the the victim. It was regarding his children. But this is the case. She never showed the first time. And again, I don't know if she's going to show the second time, but the court should.
But I've heard this bond argument before. I mean, I don't know of any circumstances that have changed from the court's perspective. It's actually gotten worse, quite frankly.
A reasonable bond to protect society.
I think the bond is reasonable. Motion denied. Court calls case of People versus Tariq Wilson.
Assistant Public Defendant Nick Bukovich on behalf of Mr. Wilson.
Mr. Wilson, is there somebody you can
He
ask
just
to help
smiles.
unmute?
I don't even know if he knows where he is right now.
All right.
There he is.
Okay.
Thank you.
Welcome.
Thank. Mr. Wilson, can you state your name, please,
They
sir?
got a really small cage.
Thank you. You're asking for an adjournment.
Yes, Your Honor, I filled out the visit application. I'm just waiting for a response. So
How How fast do you typically respond? Do you know?
Well, they told me it would take 2 days to process that, but apparently that may not have been true because I sent it more than 2 days ago.
All right, he's in MDOC.
Yes, he is.
I think the court's familiar with it as mine, and it could take weeks.
Yeah. All right, let me adjourn this out to July 16th. Well, effective defendant custody status, July 16th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Natasha Brazelton.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Brazelton. Should be appearing via Zoom.
Ooh.
Not checked in.
Yeah, I did speak to Ms. Brazelton this week. We were playing a little bit of phone tag. We do have a finalized offer, so I cannot explain her lack of appearance here today. However, I did speak to her this week, so I would be requesting an adjournment.
Bench warrant will issue for defendant's
that's what you
failure
get.
to appear.
You get a
Bond will
bench
be
warrant.
set in the amount
If you don't show
$10,000
up,
cash surety. Court calls the case, people versus Lowry
it's
Shinabar.
really not a hard concept.
For the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Kevin Genevar Lowry.
Yes, it is. I'm sorry.
Kevin Williams, Shinovar Lowry Jr.
Your Honor, we're hoping for an adjournment to review discovery.
All right. How much time? 2 weeks be enough for it?
I think so, Your Honor. Yes.
Will be adjourned to July 2nd. Bond continue.
Thank you, Your Honor.
Court calls the case, people versus Austin Bird.
Hello.
Morning, Your Honor.
Oh, here we go.
Gaga requesting permission to practice pursuant to Michigan Court Rule .120 under the supervision of Assistant Public Defender Nick Bukovich on behalf of Mr. Bird.
Permission to practice is granted. Sir, state your name. Mr. Bird,
Yes, Your
can
Honor.
you state your,
Austin Bird.
thank you. All right, what are we doing?
We're just requesting an adjournment for ongoing plea negotiations, Your Honor.
Adjourn this matter to July 16th, 2026, 9 a.m. Bond can.
Your Honor. Thank you.
Court calls the case, people versus Ayad
What he said.
Abulez.
No, for the people, Your Honor.
Your Honor, Assistant Public Defender Davi Lebo on behalf of Mr. Abuelas. Mr. Abuelas, can you tell the court your name, sir?
Iyad Abuelas. Good morning, John.
All right, what are we doing?
Andrew, I'm going to requesting to adjourn both matters for discovery, and I would like to address bond as well.
Probable cause conference, 2 weeks, or you want 3?
I would ask for 2 weeks, Your Honor.
July 2nd, 2026, 9 a.m. Go ahead, Esteban.
Thank you. With regard to bond, Mr. Abuelas has told me that he has stable housing located in Ypsilanti. He does indicate to me that he has some health issues, needs a medical appointment with regard to that next week, as well as an appointment with a psychiatrist he's going to be needing to reschedule as a result of his custody today. He also indicates to me that he has 2 children, a 1-year-old and a 3-year-old, and he's quite anxious of being separated from them, and he anticipates they feel the same way. They're currently staying at home with his wife. But if we'd have no objection to home confinement tether, and Mr. Boyles indicates to me that he could post up to $1,000 in bonds. So we'd ask
how much?
Up to $1,000, Your Honor. And so we'd ask the court to consider a personal bond or in the alternative, a 10% bond that Mr. Boyles will be able to post.
Response.
My understanding that the defendant's like just remained on your charges yesterday. And
yes,
criminal history. If the court was inclined to release him, we would also be asking for him. Okay, fine.
Well, he lives in Ipsy.
Does, Your Honor. And he has provided me with an address that I can provide to the court.
Given that argument, the court will modify the defendant's bond to a $10,000, 10% bond. Defendant must be placed on a GPS home confinement tether prior to his release.
Thank you, Your Honor.
Yeah. Thank you. Court calls case, People versus LaShawn Charles.
Your Honor, bring me to it.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Charles, Your Honor. She is
Good
on
morning.
Zoom. Judge.
Good morning. Your name?
LaShawn Charles.
All right, what are we doing?
Your Honor, I'm asking for a brief adjournment. There is an ancillary issue that I really want to clear up. The people have made an offer. I just want to confirm that everything is good in that way. I'm going to have Ms. Charles speak with someone in my office with expertise on this issue.
During it to July 9, 2026, 9 a.m. bond continue.
Thank you, Your
Thank
Honor.
you.
You need a green sheet.
Oh, I'm sorry, Judge. I have it. I may approach.
Court does call the case of the People versus Wesley Brand.
This is the Michigan Court Rule 85101. For prosecuting attorney action.
Permission to practice is granted.
Your Honor.
This is Public Defender Davi Lebo from Mr. Brand. Mr. Brand, if you state your name.
Wesley Brand.
And Your Honor, Mr. Brand will be waiving. I reviewed the waiver form that he has just executed here at the podium.
So you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged or the offense alleged was committed and that you committed it?
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
We'll also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information. We waive formal readings and stand mute at this time.
Defendant every way formal reading standing mute. Court will enter not guilty plea. Pretrial will be set for
My second at 1:30 for Judge Slay.
July 2nd, 2026, 1:30, Judge Slay.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, bond continue. Court calls case of the People versus Aaron Davis.
Haley Zinn on behalf of the people.
Oh, is it?
Yeah.
Assistant Public Defender Zach Vinny on behalf of Mr. Davis, present via Zoom. Sir, can you please state your name for the record?
Wow. Okay. That's it.
Aaron Michael Davis.
Oh, there we go. Okay, thank you, sir.
Your Honor, we would set to examine this matter.
You need an exam.
Yes.
And he is located where?
It's the new path in Flint, I believe, Your Honor.
Retreat.
Yes, Your Honor.
Okay. I'll set it for exam. Is he going to be permitted to leave treatment?
Oh, well, I had a discussion with him yesterday or yesterday, the day before, and I believe he stated that he would be able to be transported here for the exam.
Okay. Is that correct, sir?
Yes, Your Honor.
Okay. Do you know about how much time they might need to try to make that happen?
2 weeks, Your Honor.
So they can't do it in 12 days. I can
12
either
days.
do it in 12 days or 19 days.
12 days, the guy's with me, my care coordinator is with me right now as we speak. He said 12 days is fine, Your Honor.
Okay, so we can do the 30th?
Yes, sir.
All right. Then, and discovery is complete.
To our knowledge.
People have their witnesses available the 30th? All right. Preliminary examination will be set for June 30th, 2026, 9 a.m. That's before Judge Washington.
Thank you. God bless them.
Take care.
Thank you, Your Honor.
Court does call the case of the people versus Maurice Robinson.
Over to the people, Your Honor.
Studies in.
Julie Gaines, Senior Assistant Public Defender representing Mr. Robinson. Yeah.
Okay. Sir, can you state your name, please?
Please, Robinson.
All right.
Yeah, Mr. Robinson is in custody in Illinois, I believe. I was able,
Sebago County. Yep.
I was able to schedule an appointment to meet with him on June 23rd. I'd asked for a TCC date after that day.
Okay. But we're gonna need at least 2 weeks. How? All right. You've got an appointment with him on the 23rd.
That's correct, sir.
All right, so what I'll do so that we can have enough time for a writ, if they'll honor it, is probable cause conference will be adjourned then to July 9th, 2026, 9 a.m. Bond, thank you.
Thank you, Your Honor.
Thank you, sir.
I'll see you by Zoom on 23rd, sir.
Court calls case People versus Grant. Jay.
Morning, Your Honor. People.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of the.
Your name?
Grant Matthew Duche.
What are we doing?
Brad, we'd like to set this matter for.
Like to do what?
Set this matter for exam, Judge.
Discovery is complete.
Yes, Judge.
Would people have their witnesses available the 30th?
Yes, Your Honor.
All right, preliminary examination, June 30th, 2026, 9 a.m. before Judge Barr.
Thank you, Judge.
Thank you. Court calls case People versus
Man, he's
Xavier
really flying
Bauman.
through these cases today.
Your Honor, Peter Winter on behalf of, I'm standing in for Mr. Amadeo, Your Honor.
All right.
State your name for the record, please.
Xavier Bauman. What are we doing?
Your Honor, I'd like to ask that the PCC be set over to the 9th. I also understand there's a probation violation because he didn't get tested.
So right
I've
off the
talked
bat,
to
he had a
him.
probation violation.
Not only that he didn't get tested,
Sounds like he's got drug testing as well.
he didn't even report.
Which could be why he decided to miss.
I wasn't aware.
I don't know that Mr. Amadeo was his
Probation.
attorney at that time, Your Honor.
Because I'm
I
positive
have
he would
made
have
sure
drug
that
tested
he's
him.
going to, his mother is here with him today, and I'd like to adjourn the violation over to the 9th. I've made very clear to him that he's got to report this morning.
When he was arraigned, he was told to go over.
Well, I was not present. I'm just indicating to the court that I've told him very emphatically, his mother is here. He's going this morning.
Okay, is he saying he didn't know? Is that what he's representing to the court? Because he needs to be careful if that's what he's representing.
I don't understand.
No, I did.
Tell the judge.
I didn't understand. Prepare new orders. Is he working? What are you doing when you're out?
I work at McDonald's.
Well, who else?
How long have you worked there?
For like
5 months.
He lives with his mother and I believe his sister, Your Honor, and they're both here in the courtroom. His mother's here in the courtroom with him.
We'll prepare a new order for community corrections. You need to go over there before you leave this complex. You understand that?
Understand.
And so I want that order and an order for a GPS tracking location tether. And then I will adjourn this to July 9th, 2026, 9 a.m.
I'm sorry, I didn't hear when, Your Honor.
The 9th,
Thank you, Your Honor.
9 a.m. Bond continued with those added conditions.
Thank you, Your Honor.
You know, Judge Simpson's a pretty fair judge. It's one of the
Court calls
reasons I
case
actually
People
really like watching him.
versus Maisha Gaines.
I like watching Judge Fleischer as well. But there's something about Judge Simpson that I just thoroughly enjoy.
Good morning, Your Honor. Joy
Yeah,
Gaines,
yes,
Senior
he gets
Assistant
pissed
Public
off
Defender
and-
representing
but
Maisha Gaines, who's approaching. Would you please
you're a
state your
fair
name?
person, he'll be fair back to you.
I'm
He
presuming
treats
no
humans like
relation.
humans, and I
No,
think
you're
that's a
not.
Okay,
huge
all right, go ahead.
benefit of his courtroom.
Your Honor, we have come to,
This work, it's amazing. Go ahead.
Your Honor, we have come to a resolution in this matter, but need some additional time to effectuate it. It's a global resolution with a case in the 14B District Court.
All right. So does she need to get there first or?
Yes, Your Honor. She's currently scheduled, I wanted to say, for June 30th for a pretrial there, but we are trying to get an earlier date for her there. The attorneys and paralegal over there working there.
All right, but you might get the 23rd if it's an early. Why don't I just do this? July 2nd. 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case People versus Terrence Hall.
Alexander, on behalf of the people, Your Honor.
What is Bellinger doing? Who? Where is?
I think we withdrew from this. Good morning, Mr.
Hey, how you doing?
Yeah.
Mr. Winter, is this your case? You're here for Mr. Amadeo?
I have, Your Honor.
All right, this is another one of his.
State your name for the record, please.
Terrence Hall. All right.
Mr. Amadeo was appointed on this case about 5 days ago. He hasn't had a chance to speak to Mr. Hall because he was bonded out. He's tried to visit him in jail and he bonded out. So we would request this be put over to the 9th.
Any objection from the people? Probable cause conference adjourned July 9th, 2026. 9 a.m. bond continued.
Thank you, Your Honor.
Here. Court calls the cases of the People versus Taiwan Grigg.
That's fellows for the people.
Who's this?
I still correct on 2024 case.
Corrected.
Joy Gaines, Senior Assistant Public Defender representing Mr. Griggs. What you got going on?
Okay.
Wayne. Stephanie Cannon on behalf of Mr. Griggs, Your Honor. Thank you, Joy. Your Honor, we are asking for an. Did Mr. Griggs already say his name?
Mr. Griggs, apologize.
Thank you. We are asking that the 2025 case be adjourned because additional discovery has been requested. We're asking that the 2024 matter be set for preliminary exam.
I, however, I don't have a problem doing that. However, I don't have questioned, I believe, twice, not 3 times, the corrected order on the 24 case.
And my apologies, Your Honor, because I thought I had given that to the court. If I have not, I will resend it.
I don't know if,
You're correct. I received. It's one that was incorrect twice, and then I received one for the wrong case.
Your Honor, I will revise them and resend them again. I thought Ann and I thought I had fixed them, so it
that didn't.
addressed.
Well, did.
Not work out well, but
Well,
I will try again.
I'm not gonna keep waiting on this order. I'm gonna ask the jail if we can take him back
And we'll do it.
in order, then I'll bring it out. I'll be able to sign the order, then everything will be in place since we've asked for it numerous times.
No. Fix back, we'll ask them.
Thank you.
We're coming right back. We're coming right back.
Yeah. Court calls the case, People versus Hetty Dick Diaz.
Assistant Public Defender Davi Lebo for Ms. Diaz, who I am hoping is appearing on Zoom. Your Honor, I have been attempting to.
Brings eternal, but go ahead.
It does, Your Honor. Perhaps not here. I've been trying to reach her for the past few days and I have not been successful in doing that. I have generally been able to in the past, so I am surprised and would ask for an adjournment.
Bench warrant will issue for defendant's failure to appear, bond 10,000, cash here.
Thank you, Your Honor.
Court calls case versus Amanda James.
And then go with the people, Your Honor.
Assistant Public Defender Zach Vinny with my behalf of Mr. James will approaches.
You guys gotta make sure to clear that way when transport's coming through, Mr. Lebo.
Ms. James, can you state your name for the record?
Amanda James.
Thank you.
Your Honor, this is the intent set for a bond hearing. So Ms. James, as you remember, as you recall last week, Ms. James was ordered to go to community corrections to test. She did go to community corrections to test. However, she does admit that she did not go straight there. She had to go home first. She went home to get the money to test, and then her mom wanted to stop at Burger King because she was hungry, so they stopped at Burger King. Then they did go to community corrections to test, but by that point, the no bond order was already in, so she was arrested from there.
Oh, yeah. I remember.
Oh, yeah, I remember.
We didn't get a test, did we? It was positive, right? Yeah. Okay, so I told her to go to community corrections. She's here on campus. She left the building and I remember her walking out. She said, I'm going over. We sent another person slightly after her who got over there, tested, came back. We still hadn't heard from Miss James.
Ms. James indicated that her mom is here and does have the receipt of her going to community corrections the same day.
Oh, yeah, I know, but it was like she was supposed to go there and come back.
Yeah. Ms. James indicated that she did not, at the time that she was here today, or last week, she did not have the money to test, so she had to go home first to get the money. And then had to go to Burger King.
She didn't go because she needed time to get clean.
1282 Medford Drive, Huron Heights.
Listen,
So in
I'm an
this county.
ex-drug user.
Yes.
So when does it?
I
4 hours
absolutely know and
to
understand
hours to
these
go
things.
home, come back,
3 hours.
and then do that. And I don't
And
know
I
where
have
the
heart
Burger
and
King
feelings
comes
for people that
It
are
was not
still
3 hours,
addicted
Ron.
to
I was
drugs.
going 45 minutes.
I got out of it.
Yeah.
I have
can
my
get out of it
test.
too, but they gotta want to do it.
Please,
But
yeah.
these
Because
excuses
we
aren't
called
gonna work.
over.
They don't work.
She said
for the
she called you
judge.
when
They
I got
don't work
there,
for
and I sat
themselves.
for like.
I
You're
know.
only hurting yourself.
She did.
Oh.
But she did get over in test.
She did come. Yeah.
Yeah. Then she left.
Then she, what, Your Honor, I apologize.
Then she left. She didn't come back over.
They arrested me there.
Yeah, I know. Why? Because we had
You said you put the
warrant.
warrant out. Yeah.
Yeah. And she tested positive for cocaine.
As I said, I possibly would. That was why you tested. That's why you said.
That is not what she said.
Your Honor, I told my probation officer that there was
Oh my,
you
not what she said. Told me.
recall.
Your Honor, I
Not talk, turn around like that. I'm done. I'm done. Her bond remains denied. How much time do you want to put it over? I'm not playing games. I am not playing.
I apologize.
Think I am. If you're gonna turn around and start smiling and doing all that, this is not a
I was just
bond denied. I'll set it over to July 2nd.
You're not even giving my information.
Ooh,
Keep talking.
she pissed him right off. And look, she gained nothing. I'll tell you what she gained.
You want your case now,
Man, I
Ballinger?
feel bad for the person that has to follow up on that.
Courthouse case, People versus Nicholas Dragos. Dracos.
I'm gonna go on behalf of Mr. Draco.
Not check. What's been for?
Did you want to say anything or no? What were you gonna do?
I was waiting for your,
You can stare at that screen all day. That's not gonna happen.
I was sorry, I was waiting on your cue, Your Honor.
You were waiting on my cue?
Yeah, I thought,
What?
usually you say, what are we doing? But I didn't know if that was.
Oh, okay, all right. Okay, so you need a cue.
All right, well, at least he
all
calmed
right.
down a little bit.
We can
I didn't want to interrupt you.
What are we doing?
We were gonna request an
So
adjournment.
we're gonna be the same thing because your client's not here.
Right.
Yeah.
We were just gonna mention there's an intensive amount of discovery, but he's not here, so I guess my request for an adjournment might be irrelevant.
I will say.
You can make the request.
I will say.
Nick, why are you trying to save him?
Because he will save me in the past, Your Honor. Public Defender Nick Bukovich on behalf of Mr. Dracos. I will say Ms. Gaines and I had a very intensive conversation with him yesterday about this matter. So I am confused about his failure to appear today. So I would ask the court to consider an adjournment. This is a case of a very intensive amount of discovery, over 954 pieces of media on Axon to review. So I would ask the court.
You're requesting an adjournment?
Yes.
He said it was irrelevant.
My mistake, Your Honor.
I would be, for the record, I would be requesting an adjournment.
Really wouldn't matter. I'm gonna issue a bench warrant. People's requested bench warrant, bond 10,000 cash surety. Warrant will issue immediately.
Thank you, Your
Okay.
Honor.
I'll remember next time. Give him the cue. Court calls case versus Daniel Keener.
Is that on behalf of the people, Your Honor?
Assistant Public Defender Davi Lebo for Mr. Keener. Mr. Keener, can you state your name, sir?
Daniel Keener.
Thank you.
And Your Honor, we did just receive some additional discovery on this matter towards the end of the day yesterday. I'd be asking for a brief adjournment to review that and also would like to address bond.
PC will be adjourned July 2nd, 2026, 9 a.m. As to bond.
Thank you, Your Honor. With regard to bond, I did have a chance to review the calls, and it is my understanding that the calls do relate solely to Mr. Keener getting his property back and having his brother pick up that property. He understands now the proper way to do that was to call the police, ask the police to arrive there first, and only obtain his property with the
If you're
police
just joining,
present for a civil
this is
standby.
Live with
He
Cowboy.
now understands this. He knows the seriousness, no
We're
contact order.
watching
He knows that violates
Judge Simpson
the court
on
reinstated his
today's
previous
docket,
bond.
which is June
Respond.
18th, 2026.
Your Honor, I leave this in the discussion part. I
You
do
did
want
just
to
have
know
a
that
woman that
I
upset him pretty badly.
understand the calls, but I
But it
also
looks like he
would like to know
reset
that the
pretty
defendant was
good.
not very honest with the court about what those contents of those calls were. And then one of those, or two of those calls, were one was a completed to
And
the
if you are
victim,
just
her
joining,
number after he was told not to have contact with her. While it was a
we
short
do
call,
this daily.
I
We
do have
watch
concerns that
live
he called
court
her after he was
sessions
told not to
between,
call. And then also
a
about someone
lot
else
of
to get in
favorite
contact with the
judges,
victim, identifying her by name.
different kind of
So
cases,
I do
criminal
have
court, civil
concerns, and I
court.
know he was remanded last week by the court.
If you could
Um,
help out, like,
If he is
subscribe,
serious, I would
turn the
ask him to
bell
be on
on so
public
you know that when we
management,
go live
given
every
his
morning.
bond violations in custody. I would have concerns about.
I like to interact with people,
but I'm
so
gonna-
if you throw a
Tell
message
you
in
no
the chat,
contact.
I'll get right back to you.
And I don't know, and I'm unclear that his reasoning for why he
I do
says
stay
he's
quiet a lot so
contacting,
that we can hear
I don't buy
what's
it.
going on.
I mean, I think it's clear. Motion for bond reduction
But
tonight.
at the same time,
Thank you, Your Honor.
there's often a lot to
Court
talk
calls
about.
case
So
People versus Lance Ford.
we'll make comments when necessary.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Ford. Would you please state your name for the record?
Lance Ford. Thank you.
Your Honor, we are continuing negotiations for this matter and would ask for an adjournment.
Without objection, July 9th, 2026, 9 a.m.
Thank you.
Thank you. Court calls case versus Crystal Lewis.
Assistant Public Defender Zach Vinny with on behalf of Ms. Lewis, who approaches. Lewis, can you please state your name?
Crystal Lewis.
Your Honor, we're seeking an adjournment for the negotiation. Well, and then I would ask to be heard on bond as well.
Matter will be adjourned July 2nd, 2026, 9 a.m. Esteban.
Esteban, Your Honor, so Ms. Lewis is currently on a $10,000 10% bond, which is not a bond that she can post. She does have a stable place to live. She lives locally in Ypsilanti. She does also provide home health care for her long partner's mom, Your Honor, as well. She on June 11th, her long-term partner had a serious heart surgery, and she has been unable to see him or check in with him or see how he's doing or help him out. She has 2 daughters at home, an 11-year-old and a 19-year-old. Wait, is your 11-year-old a daughter or son?
Son.
Oh, sorry. I apologize, Your Honor. An 11-year-old son and a 19-year-old daughter. She will wear a tether if necessary. She will drug test if necessary. She'll do what she has to do. So she is asking for consideration of a personal recognizance bond so that she can, be out and help support her family. And then also, lastly, Your Honor, it is her birthday next week. She'll be turning 49 years old, and she would prefer to spend that with her loved ones.
I hear they have good cake at the jail. Response from the people?
Your Honor, I see that she has a benefit warrant out of the 44th Circuit Court of Powell, Ohio, State to appear for a motion to carry.
A motion hearing?
Excuse me.
That's what my notes said. Failure to appear for a motion.
What's the bench warrant out of Powell?
If I can have one moment.
Yes.
LCC. Consumption for you.
And does it give a bond?
Bond.
So it would be useless for me to release her because she'd be going to Howell.
If you were his tier, you'd be going to Howell anyway. So you'd still.
Motion for bond reduction denied. Bond will continue.
Your Honor.
Yeah. Court does call the case of the people versus Stefan Wainwright.
The people, Your Honor.
Assistant Public Defender Davi, Lebo form, Mr. Wainwright.
Mr. Wainwright?
Yeah, they're going to get the keys to open this food slot.
Okay, thank you, sir.
Evaluation. We have begun reaching out to experts for that purpose. We're hoping to find one who can do it a little bit sooner than the date we were given.
Oh, do what?
An independent evaluation, Your Honor.
So, say that again, Mr. Lebo. You're trying
That's
to get
better.
the independent evaluation.
Man, I screwed
Yes, Your
up.
Honor.
I clicked the wrong button.
You're trying to do it sooner?
Bad.
So we have reached out to one expert who could potentially do it. He's given us a day of after Labor Day. We're hoping to find someone who can do it sooner than that.
So I'm trying to get released. So if you can do a personal recognizance, we could speed this process up so you can stop bullshitting yourself. So now that you understand that, if you don't release me on a personal recognizance, there's really nothing much to talk about at this point. So it's your decision.
Alrighty then.
Because he's not my attorney. I'll pay for that. I have plenty currency. That's not a problem. But if you guys would like to meet in person, be much better. So I actually have a meeting to go to. I'm a little busy. So let me know, they'll let me know up front. What's your name? Samson? Okay, let me know. And then once you do that, we can meet in person. I have a couple clients that I have to take care of right now.
I'll meet in person with anybody. I don't mind. All right.
He was in person yesterday.
Dependent.
Yes, Your Honor.
I think so.
That was awesome.
This was set, his competency, I adjourned his competency hearing to the 18th.
Yes,
You need that adjourned out because you're trying to get the independent.
exactly, Your Honor. Thank you.
All right. Any date
That
in
that
August.
made my day, I think. That was great.
Set it now. I'll adjourn it out to August 6th, 2026, 9 a.m. Bond at this point will there we go. Thank you. Thank you, sir. What? No, don't. I'm
Sam
Samson.
Samson.
No. Court calls the case, people versus Kalani Franklin.
It's so great that he was able to just laugh that off because
And good morning, Your Honor.
that was absolutely hilarious.
Kalani Franklin Croachman.
I hope that guy
Kalani,
knows
state your name for the
that
record.
he is going to be a YouTube star.
And the court.
I will be cutting this video
Form
and making
indicate.
a short out of it. People will love
Okay, I guess the added count too is retail fraud third.
Third degree, yes, Your Honor.
All right, the 93-day. Upon her successful plea to that charge, count one would be dismissed. There is an agreement or prosecutor will recommend sentence under HIDA.
Yes.
That's the court's full understanding.
That's correct, Tom.
Yes. And Ms. Franklin is prepared to enter that.
All right, may I have her sworn?
You're telling me swearing in front of that, just about to get the whole truth, nothing but the truth.
Can counsel approach, please?
It's a good day, ladies and gentlemen. It is a good day. Why? Well, I don't know, but I'm alive, you're alive, and we got some funny stuff going on.
All right, record should reflect we've had a brief bench conference in this case. And may I have her sworn?
Do I'll be sworn to affirm the testimony about to give you, nothing but the truth, so help you God.
Yes.
State your name for the record.
Kalani Franklin.
Franklin, is this court's understanding that you're gonna plead charge of retail fraud in the third degree? Is that correct?
Yes, Your Honor.
That's a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that? Right. Still wish to plead guilty?
Yes, Your Honor.
That charge, how do you plead?
Guilty.
You understand by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll bring up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you bring up your right to appeal outright.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's on the record to get you to plead?
No.
Anybody threaten or coerce you?
No.
You're doing this voluntarily
Yes, I am.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense. Here's why. Oh, anyway. On the date of December 22nd, better, 2025, at the location of 1254 Horse Road, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do at Pet City Pets that makes you think that you're guilty?
Pet City Pets.
I took a puppy.
Aw.
Store was open to the public at the time.
Yes, Your Honor.
You didn't have anybody's permission to take that puppy, did you?
No.
And this is the puppy they had offered for sale.
No.
Why'd you take the puppy?
Because it's a puppy.
I wanted to replace my daughter's puppy that had recently got stolen.
Aw. See, I got a lot of heart for animals, man. I know she went about things the wrong way, but
And this was 3 days before Christmas.
that poor thing.
How old's your daughter?
3.
At the time, was she 2?
He understands. He understands. I got heart in this case right here. I feel bad.
I do have to advise you between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
People?
None from defense, Your Honor.
Have I complied with the court?
Yes, Your Honor.
Second, really?
Yes, Judge, we are satisfied.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be before me on
July 22nd at 9 a.m.
July 22nd, 2026, 9 a.m. Bond will continue. And Ms. Wyman, could you? Mississippi. All right. You'll be before me. You can stop down at my probation department right down the hallway on the left-hand side. So we'll get it started, okay?
Okay, thank you.
You're welcome, man.
Thank you, Your Honor.
I liked her.
Court calls the case, People versus Merrick Lincecum.
I know it. And right here.
Assistant Public Defender Chinazi Carey, I can rule, Your Honor, on behalf of Merrick Lincecum. Merrick, state your record.
Mayor Clayton Everett, let's go. Good morning, Your Honor. Good morning, sir. I have before me a plea form that indicates the defendant will be pleading no contest to an added count 3 of retail fraud, 2nd degree, the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. Defendant agrees to pay full restitution at the time of sentencing. That's the court's full understanding.
That is correct, Your Honor. So you understand?
Yes. May I have him sworn?
Raise your right hand. Solemnly swear and affirm that the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth to help you out.
Yes, sir.
Now state your name for the record.
Mayor Clayton Everett, let's go. Sir, it is this court's understanding that you're going to be pleading no contest to the charge of retail fraud, 2nd degree. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? Sure. You also understand, do you understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. The first is that it means that you're not further desirous or wanting to contest this charge. You understand that? The second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Sure. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. I'm sorry. Basis for the no contest plea?
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead? No contest. Now, you understand that by pleading no contest, you'll not have a trial of any kind. Sure. Signed in advice of rights form, is that correct? Any question regarding those rights? No, Your Honor. Please look at paragraph 5 on the podium. Those are your rights which are part of a trial. And by pleading no contest, you're giving up those rights as well as all the rights on that form. Understand. Understand you're giving up your right to appeal of right. Understand. Are you on probation or parole? Yes. You're on probation or parole at the time of this? No, this is from 2023, I believe, right? Yes. But I was not. I was on probation a little bit after, but okay, but not at the time. All right, thanks. Has anybody promised you anything other than what's been stated here today to get you to plead? No. Did anybody threaten you or coerce you? No, Your Honor. You're doing this voluntarily? Yes, Your Honor. Of your own free will? So, all right. The court has been handed and has reviewed Washington County Sheriff's Office report for their case number 23-53023. Any objection to the court reviewing that report?
None from defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? Yes, I understand. All right. Counsel, you're aware of any other promises, threats, or other inducements which have led to this plea?
None, Judge.
And have I complied with the court rule?
Defense is satisfied.
Court will accept the no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing will be
July 6th at 9 a.m.
July 6, 2026, 9 a.m. before Judge Freshour. Bond continued. Thank you.
Oh, here, bond continues on.
Court calls the case of People versus Robin Hardy.
Hardy.
That's the balance of people.
Good morning, Your Honor. Ashley Hannibal for Robin Hardy, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Where's Cannon? Not even paying attention. Drop your bags, you're still analyzed. Permission to practice this grant.
All right. We're just requesting an adjournment today. I'm just requesting an adjournment today for plea negotiation.
Do you hear? Ms. Hardy?
Yes, yes, I'm here. I'm trying to get the camera to work.
Okay. On Cannon's cases.
Okay.
Okay, there you are. State your name.
Robin Hardy.
All right. You're requesting an adjournment.
Yes, Your Honor.
Probable cause conference will be adjourned July 9th, 2020.
Your Honor.
Thank you, Your Honor.
Bond continued.
Thank you.
Yep. Just gotta.
Court
keep
calls Z
tapping that
cases of the
there.
people versus Michael Moore.
Your Honor, Raymond Cook for the people.
Joy Gaines, Assistant Public Defender, written on behalf of Mr. Moore.
On all six.
Please state your name.
Michael Moore.
Your Honor, we are in the process of negotiations. We just recently received the mitigation letter from, as in this week, received the mitigation letter for us to present to the prosecutor. So we're asking for a short adjournment, maybe 2 weeks, so that we can continue negotiations. And we'd also like to address bond for one of the
cases?
One of the cases, Your Honor. For all of the cases except for 26 F5-5051, Mr. Moore has a bond of 1,010%. We're asking for a 1,010% bond on that matter as well. If the court would permit that bond, Mr. Moore is stating that he believes he would be able to post all of the bonds and get himself into a substance abuse treatment program. That we have been working diligently to get him in that. There's already a release to treatment on all of the cases. We are working to try to get his holds in Dearborn cleared up. He was able to get one. There's one more that we're still working on that is then a bit more challenging, but he would be able to go to treatment. Your Honor was able to do that.
I'll adjourn all of these to July 2nd. Do the people have anything they want to say regarding bond?
Maybe you approach, because I have something that I think addresses both the adjournment as well as the bond.
All right. Yes.
Looks like they need a private moment here. Hopefully it won't take too long. And we can get back to it. I will be right back, folks.
Motion for bond reduction. The record should reflect there's been a revenge conference. Motion for bond reduction will be denied in that case. Court will continue the bond as set. I will adjourn all of these to the second. 9 a.m. Thank you.
Looks
thank
like
you.
we're back.
Court calls case People versus Dean Hodder.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Hodder, Your Honor.
He was what?
Well, it's just a courtroom I just saw. Your Honor, may we pass this matter? Perhaps he's in the restroom.
Yeah, perhaps.
I mean, he was in here.
Over at community.
He was here. Yeah,
Sure.
long beard. Yeah.
So if he doesn't show up, you can go into custody? Yeah, okay. I'll pass it. It's probably Bellinger. I'll pass it. What are they doing?
Wait, can you see what the next case was, please?
So we can go look for him, Your Honor.
Not telling. Court calls case People versus Lee, Pat.
Back to the people, Your Honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Patton, who's making his way to the podium, Judge.
Public defenders doesn't take findings. Like 3, that's blue. Anyway, your name, sir?
DeAndre Fed.
Thank you. What are we doing?
And we're asking for a brief adjournment in this matter to review discovery as well as discuss potential next steps with Mr. Patton. The people have made a waiver offer regarding a potential sentencing issue that they're agreeing to keep that open.
Correct me.
July 2nd, 2026, 9 a.m. bond continues.
Thank you, Your Honor.
Court calls the case of the People versus Daniel Healy.
Oh, the people.
Michael Gaddy, Assistant Public Defender on behalf of
Your name?
Daniel Hewan, sir.
Take your hands out of your pockets, please. What are we doing?
Your Honor, we're asking for a brief adjournment to continue plea discussions with the people.
July 9th.
Support received the bond violation report. Quantified progress report is done to change the defendant's most recent past, which is positive for an ATG.
Yes, it does. You been drinking?
Yes, Your Honor.
Oh boy.
You're not supposed to be kept. Did you see it?
Yes, Your Honor, I have had a chance to see the report. I too interpreted the positive for ETG not to mean that he actually just took a test, but that it came back positive for alcohol. Mr. Heelan does, well, as he just told you, he did drink. He is working. He has a prescription for the other substance that was indicated. He is working to make positive change. We'd ask the court to consider his unequivocal and honest response to the court in regards to the violation, and perhaps give him an opportunity to continue testing, remain outside of custody, and continue dealing with these matters.
You completed Bear River?
Yes, Your Honor. I know, I've just been going through it. I'm still waiting on my place. I'm just right there and I just got changes on the way. I'm going through it, Your Honor. Again, not making excuses. I own my actions.
I think he is in line for a voucher or
Right there.
a subsidized housing unit, Your Honor. We thought it was going to be Miller Manor, but it appears it'll be Arbordale now. But he is
Where?
Arbordale.
There was a clerical error, Your Honor.
No, I got it.
We've been here a few times over the last month or so. It looks like on 514, my notes indicate he had not been going to community corrections. He was ordered to appear in person. And then we understood that he was testing at home of division, but those results were not being released to community corrections.
Right.
Then on the 21st, we're back again. The home of division results were supposed to have been sent over. I asked for a test that day, but the defendant had no money to test. The court was very sensitive to the housing needs of the defendant and did not want to mess those up. So the court allowed him to stay at liberty. The concern of the people now is that we haven't really had any. The tests that we've had since Bear River have just been since the 21st of May. We do have this positive alcohol test, and as sensitive as I am to the defendant's need to secure his housing voucher, the concerns I have are the support that he's getting. It seems like it's not a sufficient level of support to keep him from drinking or using drugs. So I am concerned about his ability to remain compliant with his bond condition.
Your Honor, he is as indicated, is working with Home and New Vision according to the bond report. It appears that Home and New Vision has released the results to Mr. Heelan, and those have been sent over. I didn't quite understand the language in the bond a report that they will have to apparently go through. The way I read it was they'd have to go through Home and New Vision to him to community corrections. I don't know if that in fact is the case. I don't know if they would perhaps agree to release them to me so I can send them along. But that was a bit of an unusual circumstance when I read it, and I got it yesterday afternoon, so I didn't really have a chance to follow through.
I tried to get them released. I'm trying. It's a headache. I'm trying to get them to just straight release them at all.
I feel for this guy, man.
How
Stuff
often you
happens
been
in life.
drinking?
Not often, Your Honor. I was
It
actually
always will.
just
Well, no. Listen. How often are you drinking?
not often, like a couple of times, period. Like I'm not a big. I'm trying so hard. I just
I feel
going
bad for
through
this
it.
guy.
It was a 1-year
It sounds
anniversary of
like
my
he's
father
actually
passing, and
trying.
I'm not making excuses. I
mean,
went
it's-
off the hinges a little bit.
It's an
But
unfortunate
I'm
situation.
trying to
all
keep
the way
moving
around.
forward. Again,
I
I
mean,
haven't
we all have to
gone
pay
back to the
for
worst things,
our
and I'm
actions
proud of
what we
myself
do,
for that. But I was very disappointed in myself.
What type of treatment? You're at Home and New Vision. What
He
type of
sounds like an
programming are
honest
you
guy,
in
though.
over
But
there?
he knows he messed up.
Intensive outpatient. I see Elizabeth Aoki specializes in intensive outpatient treatment. I just really started with her. I'm just.
How often are you seeing her?
Once a week, sir.
Anything else during the week?
I've been attending some meetings. I'm trying to find some.
How many supposed to attend?
I mean, I don't have a supposed to, but I should be going to one
You
of
want to stay sober.
at least
How many meetings should you be attending?
one a day, sir.
And
That's the
how
truth.
many meetings have you been attending?
And I say that from experience.
About one every 3.
You should be going every day. That support group, AA, is a remarkable program.
So
when used
bottom line
appropriately.
is, you're not
you
doing
have
the
to
stuff
want
to
it.
even help yourself right now.
I need to step it up. I need to step it up.
So if you've been doing this, tell me why I shouldn't put you in jail today.
It'd be counterproductive for me just going to jail.
Well, what you're doing is your life is counterproductive right now.
Still making some positive progression. I am making positive progress and I'm trying hard.
Where's your housing thing right now?
I'm right there.
Help the
I
guy
just
out.
did the new referral packet. There was a clerical error. They didn't have units available, so I kind of had to start over, but I'm right there. Like within the next week or two, I'm gonna have my own place. The first time in a long time.
I personally hope the judge helps him out. Everybody should have the chance. He should be going to more AA meetings. If he's serious, AA is a beautiful program when used the way that it's intended to be used. But that requires daily meetings. And it helps. Narcotics Anonymous does the same thing. I'm telling you these things because I've lived it. I am sober, and I'm proud to be sober. But it was not easy, and you have to want it. This is not something that just clicks. You're going to live with it the rest of your life. I live with it every single day. Those demons don't go away.
You don't get that housing,
but it's
that's
a
gonna be
choice.
an absolute disaster for you, isn't it?
I hope he
Sure.
makes the right choice.
Even more so than what you're doing with your life right now.
I like this gentleman.
So bad, you know.
I feel
just
for him
want my own place
because
so much.
of my situation.
I'll be able to work. I'd be able to take showers and actually be able to function. Just want my own place so bad.
Why are you messing it up?
That's $1 million question, Your Honor, but the flip side of that is I know it's a mess up and I'm honestly reconciled with myself and I'm trying. And I've talked to Elizabeth. I'd like to start seeing her twice a week, but there's a full schedule. That's right now. She just got to work that in. And I really do know that I've got to step it up and I'm willing to do that. The reason I haven't been going to any meetings is honestly, I don't have a lot of transportation and I don't.
You can walk to a meeting. There are meetings all over. You can walk.
That is
Well,
true.
I'm trying to find
there are
some-
meetings
no,
everywhere.
I'm not,
a new one.
I am not gonna even hear that. Cause you know that's not true. You can walk to a meeting. There are
You
meetings
gotta
going
want
on all over the place.
There's no ifs, ands, or buts. You have to want it.
Here's what I'm gonna do. In order to defendant is to report over to community corrections placement on Scram County.
Thank you.
And I want you to get a sign-up sheet and have it filled out that you've attended an AA meeting every day from
It's a good
today forward to the adjourn date. You're to bring that with you to your adjourn date, and I
It's a good
want to
idea.
see it. Follow me? Miss a day, I'm putting you in. Comes back, take your hands out of your pockets. You miss one, I'm putting you in. I'm not even listening to any excuse as to why you didn't get there.
Sure.
If it comes back with any alcohol in your system, you're going. I'm just gonna let you know how I'm gonna handle it. Because I'm not sure I should be giving you this chance.
Thank you, Your Honor.
During this to July 2nd, 2026, 9 a.m.
To report to community corrections right now, Your Honor.
Yes, he needs to report right now. Don't leave here without going over.
Your Honor.
I have given him instructions.
Thank you, Your Honor.
Thank you.
Courthouse case,
I
people
feel
versus
for that
Kenneth
guy.
Perry.
I really do. I wish
Yeah,
him nothing but the best. I hope he gets the help he needs. I hope he follows along with the program.
Good morning, Your Honor. Ashley Hannibal for Mr. Perry.
I wish him nothing
Your
but the
name?
best. I know he can
Sure.
do it. He knows he
What
can
are we
do
doing?
it.
We'd like
He's
to
just
set a
gotta wanna
preliminary
do it.
exam.
Discovery is complete.
But
Yes,
I
Your
feel
Honor.
for him.
You will have the witnesses available the 30th. Preliminary examination will be set June 30th, 2026, 9 a.m. before Judge Washington.
Great. Thank you.
Courthouse case, people versus George Henderson.
And is that on behalf of the people, Your Honor?
Public Defender Tanaka Carey, I can review, Your Honor, on behalf of Mr. George Henderson. Mr. Henderson, state your name for the record, please.
George Henderson. Thank you.
1 second, yes.
Really? What are we doing?
Judge, we are setting this, nope, we are asking for an adjournment.
What? You don't, what are you doing? Setting it for?
Setting it for an adjournment.
Sir, you're okay. You're fine. What do you want me to do with?
I got a green sheet, Judge. We're gonna set it, we wanna adjourn this now. No, thank you.
Sir, I'm gonna adjourn your man. Huh?
Have contact with Mr. Henderson, try.
Don't try to blame Mr.
I'm not. Right. Go ahead, what'd you in?
This is not your fault. It is all her, right? Yeah. Okay, remember that. Yep. He threw you right under the bus. July 9th.
Thank you, Judge. Okay, I'm gonna talk to you.
Krista. Yeah, thank you. Said it. Calls the case of people versus Arnold Preston.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Preston. Would you please state your name, sir?
Arnold Preston.
Your Honor, we are requesting an adjournment. There is some outstanding discovery forensic interview. We'd also like to address Bob.
How long will that part of the discovery will it take to get to them?
I sent a signed executive order to Your Honor this morning, so we sign up.
We have not.
We have
You
not
know,
yet.
Holiday some more, I would assume early next.
All right. And I'll adjourn the matter to July 2nd, 2026, 9 a.m. Esteban.
Your Honor, Mr. Preston works for Edge Facilities. He's worked at that specific location for years. He's worked for the family of companies a total of 3 years. He's the night shift supervisor. He he is in danger of losing his employment, and he is asking that the court consider that and grant him a personal recognizance bond. He indicates that he would follow any orders of the court, including any orders regarding contact or any other things that the court might think were appropriate to assure his presence. He is originally from Michigan. He did spend some time in Indiana, which is where the his children involved in this matter live, but he does have ties here in Michigan. And again, he's working, and this is where he's originally from. He has his mother and other family here.
From the people.
Your Honor, this is, at this time, I would object to any modification in bond. This is a criminal sexual conduct matter concerning whether the defendant's minor children. Although they were some time ago, the defendant does have 2 previous CSC convictions on his record.
Thank you.
So given that information, given the defendants, of course, would have intimate knowledge of where the victims are. Litigation, things of that nature. Checks to modification.
Motion for bond modification is denied. Bond will continue.
Thank you.
There.
Anything else?
Court calls case versus the Peter Beisha.
And Assistant Public Defender Nick Bukovich on behalf of Mr. Ivesha, who should be appearing via Zoom. I believe he is under the Motorola.
What?
He should be under the Motorola.
That him?
If you remember, Your Honor, yesterday we had a similar issue.
Yes, we did.
Hello.
Hello, state your name.
My name Peter Iveza, Your Honor.
Okay.
Okay. You don't have a camera, do you?
I do have camera, but doesn't know work. I don't know to work with this one. I see you guys, all of them pictures and forth, but I see you guys, but
oh, we got you. We got you. We can see you now.
All right.
Your Honor,
better than what we did yesterday.
Yeah, we have made progress since yesterday, Your Honor. As indicated on the green sheet, I would be requesting an adjournment to have him work with my mitigation team to make a mitigation report to provide to the prosecution.
When did we adjourn his case yesterday? You didn't.
I believe it was the 15th, Your Honor.
15th. Okay. Then let me do this because the day-to-day seem to back-to-back days work for him. I'll adjourn this out to July 16th, 2026, 9 a.m. Bond continues.
Thank you so much, Your Honor.
Thank you.
Your Honor.
Take care.
Thank you so much. Bye-bye.
You're welcome. Take care.
Bye.
Bye-bye. What he said. Wow. Okay, there. Okay. Let's get busy. Court calls case People versus Martez Richard. Oh.
Public Defender Jay Bellinger on behalf of Mr. Richard, who approaches.
Decided to do something today. I just said, never mind, my bad.
I Huckleberry fend my cases out, Your Honor. That means if you get them to think that painting the fence is a lot of fun, then you get them to go on the record for you. Great.
Sir, what's your name? Richard. Thank you. What are we doing?
Your Honor, I am seeking to set this matter for preliminary examination today, and then I would ask to address bond, both cases.
Preliminary examination in these matters will be discovery is complete.
To the best of my knowledge.
People have their witnesses available the 30th. June 30th, 2026, 9 a.m. before Judge Barr. As to bond.
As to bond, Your Honor, we would respectfully request that Mr. Richard be released on a PR bond subject to any reasonable conditions the court deems appropriate, including a GPS tether. Mr. Richard, from my understanding, had an initial failure to appear, which we'd argue was not the conduct of a willful disregard for this court's authority. At the time, he was homeless and did not receive notice of the court date. Since then, his circumstances have significantly changed, and he has taken some significant steps to stabilize his life. He just completed substance abuse treatment, has been accepted into a sober living program where he now has stable housing in Ypsilanti. He also has reliable transportation through the sober living facility, eliminating many of the barriers that previously contributed to his instability in that regard. In addition, he also has significant family responsibilities. He's the caretaker of his disabled mother and recently welcomed a newborn into the world. A newborn, unfortunately, he has not been able to meet yet. He recently suffered a devastating loss, that of his brother, who passed away a few weeks ago as well, Your Honor. And so,
it's a tough situation.
In addressing any concern related to public safety, he's fully willing to be placed on a GPS tether, comply with any additional bond conditions the court believes is appropriate. He's willing to utilize third parties for any necessary trailed exchanges, ensuring that there is unnecessary contact related to this matter, and fully understands the no contact order that's in effect. So we would respectfully be asking you to consider, please, a conditional release on a GPS tether and any other appropriate conditions that you might deem necessary.
Wrong.
So I'm gonna object. According to my notes, failed to appear back in March of 2025. At the time of this failure to appear, he was present in court. People brought up bond violations at the time for calling, texting, trying to connect with the victim on Facebook. And after the court passed the case for us to try to get a report from YPD, when it was recalled, he had left. So I have concerns that he was present, heard about violating bond at the time, failed to appear and was not back around until this year. I would have concerns that he coming back to court and his ability to follow court orders, especially given that it took him so long to come back, knowing he had left court against court orders. It was my recollection as I handled that case that day that the court was very clear that he needed to be at the courthouse and not. So I would have concerns. It would be objective.
How did he come into custody? From the warrant?
I turned myself over to police when they tried to get me.
Your Honor, my client advises that he turned himself over to the police. But how did that happen?
Yeah, I was at want to tell him to.
You're at what?
Want to tell him to.
Yeah, you can tell him.
I was at the library when they approached me. They asked me my name and everything. And I told them my name and I told
You didn't go to the police and turn yourself in.
I think he's arguing, Your Honor, that he didn't resist arrest at the time.
I will.
But that would have just been an additional charge.
Understood.
All right. I mean, but he didn't go knowing that he had a warrant. He didn't go turn himself in. That's what I need.
I was just now getting stable and I'm back stable now, Your Honor.
And I think part of the problem at the time, Your Honor, was that was the fact that it was without a home and didn't have a lot of notice in that regard. We had issues with contact early on as well.
I just want to see my daughter. I haven't saw her since she was born because I was in here.
I understand that, sir, but
I will come back.
well, but you didn't before. That's the problem. And so I don't know that I can trust you to come back because I passed it so that you could talk to your attorney. I recall and deal and get a cogent argument as to the bond violations, and then you just took off and didn't come back. Doesn't work that way. Motion for bond reduction is denied. Bond will continue as is. And after exam, maybe who's that before?
Judge Barr.
Barr will feel differently.
Okay.
All right. All right. Thank you.
We will address it before Judge Barr.
Courthouse case versus Curtis Jackson.
Morning, Your Honor. Raymond Cook for the people.
Assistant Public Defender Davi Lebo for Mr. Jackson, who is on Zoom.
State your name.
Curtis Jackson.
What up?
And Your Honor, I did have some conversations with Jackson. Yes, he's indicated to me he'd like some more time to consider his options if requesting a brief adjournment.
Adjourn it to July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Court calls. Well, yeah. Sharp is oh, there it is. Court calls the case People versus David Sharp.
Joy Gaines, Senior Assistant Public Defender, with it on behalf of Mr. Sharp.
State your name, sir.
David Warren Sharp.
Thank you. What are we doing?
Your Honor, we're asking for an adjournment. We requested some additional video discovery.
During the matter, will that be available soon? July 2nd, 2026, 9 a.m. Bond continue. Thank you.
Thank you.
Court calls case People versus Eric Jackson.
That's all.
I got a Peter bond on the charge. Yeah.
Okay. Joy Gaines, Senior Assistant Public Defender representing Mr. Jackson. Would you please state your name?
Jackson.
Your Honor, Mr. Jackson has been working with our AIM division and had an appointment with the midnight special that he had to reschedule. We're requesting a 2 to 3 week adjournment so that we can get that letter done.
July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Bond continued. Court does call the case People first. Taiwan Grid.
At the bottom of people matters.
Who?
Actually, I can really, Your Honor, standing in for Miss Stephanie Cannon, who stepped outside. Mr. Your name for the record.
Taiwan Griggs.
Judge, I don't know if the court is in receipt of the documentation
The,
corrected,
yes, we have it. All right. And I believe she wanted, well, she's here now, finally.
I'm sorry, I was in the booth with Mr. Briggs. My apologies. We are asking that the 24 case be set for a preliminary exam. The prosecutor is working on discovery as to the 25th case, and the amended information or amended forensic order is in with the court.
So the 24 case you want set for exam, discovery is complete in that one.
Yes.
And the people have their witnesses available the 30th.
I have not checked that date, but we'll try. Your Honor.
All right. So the 24 case that will be set for preliminary examination on 30th, 2026. 9 a.m. for Judge Washington. The other matter, what's the timeline on discovery?
Your Honor, I think it's either going over today or it went over yesterday. So very
Okay. And then I'll set that one. I'll adjourn the probable cause conference to July 2nd, 2026, 9 a.m.
Thank you, Your Honor. My client is asking that he allowed to be released to the care and custody of his sister on tether. She is trying to, she was his guardian. She's not his guardian anymore, but she is accepting him back to the house. He does want to go back into inpatient treatment. The court has signed an order allowing that. His Wayne County was his Wayne County hold was cleared. They gave him a PR bond in that matter. And he has the paperwork to show the PR bond. He wants to go home. He has health care. He has SSD, I believe. So he has the ability to get into treatment. So he's asking that he be allowed to be released as well. And he'll go directly into treatment once he wants to take care of a few things. To be clear, he discussed his personal care. He's very, he wants to get that together. There's things that he discussed with me, Your Honor.
Yeah, I think we've addressed bonds several times on
Absolutely.
cases. I will note just, if I recall correctly, the court did grant a release treatment for the needless objection, which is fine, but I will also note, and I think it's worth considering by the court, that the defendant did get the 2025 resisting and obstructing case the day after he missed court on the 2024 assaulting, resisting, or obstructing case. I think that if it's going to be anywhere that's not in custody, would need to be at a treatment facility because he doesn't appear to be able to remain law abiding when he's out on his own.
I'm gonna, at this point, as I have before, deny the request for bond. Bond will continue in both matters.
Thank you, Your Honor.
So, can I ask a question? So this, I would be released to treatment then?
No, the release to treatment is still in place. If treatment's available, if they get it bad, you'll be released to treatment.
Yeah, they told me that it'd be anywhere between this time and Monday, you know, that, but
If it happens, then it will happen. But
It's the court is understands that you have been He just wants the court to know that he has been screened and the bid is available by Monday, he hopes.
Yeah, then if that happens, then he can go. I did that over the people's objections because the reality, Mr. Griggs, that's what you need. You need treatment.
Thank you.
And so I'm willing to allow the release under those circumstances so you can get the help you need.
Thank you.
I comprehend.
Thanks.
And Your Honor, depending on the length of that program,
He
if he is
comprehends.
released on Monday, with our examination being on the 30th,
Right.
I'm not sure whether or not he'll be available to come. So if defense counsel gets any information about that, they could let us know. So call.
Skip, all right, and get that moved.
Yes.
All right. Thank you.
Information for me.
Court calls the case, people versus Roderick Jacob.
So we have people over there.
And so actions on behalf of Mr. Jacobs, who's present and standing to my right, Your Honor.
My name is Roderick Jacobs.
What are we doing?
Your Honor, we're requesting an adjournment for
Oh,
additional
fine.
discovery.
The public defender's office, that's what you're asking for, isn't it? No, I'm kidding. All right, how much time did you need?
It should just be a couple weeks would be a fine.
July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Court calls case, people versus Robert Schelberg.
Listen, on behalf of the people, Your Honor.
Assistant Public Defender, shall be carried out in room, Your Honor, President Shelberg, who is approaching. Mr. Shelberg, state your name for the record, please.
Robert Gerald Shelberg.
Thank you,
Your Honor, maybe approach.
I guess. Came all the way down
I
here.
guess.
I'm in a good.
Sorry, guys. I'm trying to take care of something important at the same exact time, so.
All right, record should reflect that at the conference in this case. What I'm gonna do is I'm gonna ask you to take it back. I'm gonna pass, gotta have a question answered about an amended complaint.
Okay,
Back out. All right, thank you.
thank you, Judge.
Is that person? Probably not. Watch. Court recalls case, People versus Dean Hodder.
Ashley Phelps to the people.
Michael Gaddy, Assistant Public Defender, with Mr. Hodder, who is approaching as I speak.
Where was he?
State your name for the record, sir.
Dean Hodder. Couple things you wanted to adjourn.
Yes, Your Honor. I did get a copy of the bond report.
Out of your pocket. Oh, okay.
I did get a copy of the bond report, Your Honor. As it indicates, Mr. Hodder has gone to community corrections. He's made contact with them. He's gone and has been unable to test for financial reasons.
I'll go test it. I'll maybe come to court first.
He reports that he was going to test today, but they told him to go to court first.
You have the money to test?
I got $10.
Pardon?
I got $10 on it. Oh, yeah.
Okay, you're gonna have to figure out how to get this done, sir, but go over to community corrections and test.
Okay.
Okay. I'll adjourn this out. How long an adjournment did you need?
Yeah, I believe that this is a situation where the people need to contact the complaining witness if there's a potential resolution here. So
July 9th.
July 9th.
July 9th.
July 9th. Thank you, Judge.
All right. But get yourself over there to test, all right? But
Okay.
Notice.
court calls the case, People versus Darius Jones.
Ashley Phelps to the people.
And so questions on behalf of Darius Jones, Your Honor, who's present standing to my right.
All right, your name? Darius Jones. You're asking for an adjournment,
That's correct, Your Honor.
July 9th, 2026, 9 a.m. Bond continued.
Thank you.
Court calls case, People versus Kawanda K. Thomas.
Good morning, Your Honor. Ashley Hannibal Thomas.
State your name.
Corey Thomas.
What are we doing?
Would like to preliminary exam.
All right, discovery is complete
Yes, Your Honor.
and people would have their witnesses available the 30th. All right, preliminary examination will be set June 30th, 2026, 9 a.m. before Judge
Bar.
Bar.
All right.
Bond continued. Thank you. Court calls case, People versus Walter Junius.
Joy Gaines, Senior Assistant Public Defender, representing Mr. G. Would you please state your name, sir?
Walter Junior.
Now, we have requested some additional discovery, asking if there is dash cam and body cam footage with regard to these allegations. We're asking for an adjournment.
July 16th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you, sir.
See you, sir.
Court calls case, People versus Ches Williams.
Alexander, we have.
Oh, Shay Williams.
Shay Williams.
Yes.
It's Shay? Right.
Assistant Public Defender Chinazi Carey, I can really on behalf of Mr. Shay Williams. Mr. Williams, state your name for the record.
Shay Anthony Williams.
Shay?
Yes, Shay. Yes. Yes, sir.
Really?
Apostrophe E.
Just change.
Apostrophe E.
Just change. All right. Just change how it's pronounced.
So it's
He's trying to do
apostrophe.
a French thing.
Yes, that's pronounced.
All right.
Oh, not spelled. Okay. It's French, Judge.
It's French? I know, that would be French.
Yep. Your Honor, we respectfully request.
Was it French when you were
Probably not.
named you?
I believe so. That's because she named me after some place in Detroit. It was a restaurant, I think. I don't.
You got named after some food? Okay.
That's
Oh, that's all right.
Have you been there?
I get it. So, okay, so it is French. That's what I said. All right, what are we doing?
Your Honor, we respectfully request that this matter be set for preliminary exam.
Both of them?
Yes, Judge, both matters.
All right. Discovery is complete on both matters,
To our knowledge, yes.
and we'll have their witnesses available the 30th.
Yes, sir.
All right. Preliminary examination will be set June 30th, 2026, 9 a.m. before Judge Washington. Court calls the case People versus Jason Martin.
Your Honor, Raymond Cook for the.
Morning, Your Honor. Ashley Hannibal for Mr. Martin, who is appearing by Zoom.
Yep. Martin, can you state your name, please?
Jason Martin.
Thank you. What are we doing?
Like to set a preliminary exam.
All right. Discovery is complete,
Yes, Your Honor.
and people have their witnesses available the 30th.
We'll do our best, Your Honor.
Preliminary examination, June 30th, 2026, 9 a.m. before Judge Barr.
All right. Thank you, Your Honor.
Thank you.
All right, thank
Court-
you, Your Honor.
You're welcome, sir. Court calls the case, People versus Larzell, Washington.
Assistant Public Defender, Chinazi Carey, I can rule, Your Honor, on behalf of Mr. Larzell Washington. Larzell, state your name for the record, please. Sorry.
Good morning.
Morning.
Larzell Washington.
That's French. No, go ahead.
Right. So you're asking for an adjournment. We're negotiating with the people.
All right. Matter, July 16th, 2026.
Thank you, Your Honor.
That work for you, sir?
Yes, sir.
Okay.
Thank you.
You're welcome.
For next
Court calls
paper.
case. Coming up, or
Yeah, he's refusing.
he's refusing again. Court calls case People versus Dennis or Zachariah or Ruska Dennis.
Jacob Kennedy for the people, Your Honor.
Ashley Hannibal for Mr. Krishka Dennis, who is not appearing.
Yeah, he's refusing to come up.
Yeah.
What they do with this other one? Because they think we're all waiting.
He's
on
refusing
competency
to come
anyway.
up.
Oh. Okay. I think these are all separate problems. These both out to July 16th, 2026, 9 a.m.
Thank you.
Thank you.
Court calls the case People versus Romeo Smith. Who's in custody?
He also.
Romeo Smith? Yeah, but I need an attorney. Cannon, you're not doing anything. Step up to the podium. Oh, Pete,
Pinky.
that was. Oh,
I
all
would,
right.
I would. Michael Gaddy, Assistant Public Defender.
Your client doesn't want to show.
Your Honor, we'd request an adjournment in that.
I'll adjourn it over to the July 16th, 2026, 9 a.m. Court calls the case People versus Mamadou Diallo.
Assistant Public Defender Donzi Leap on behalf of Mr. Diallo. And my understanding is that the facility where Mr. Diallo is housed has not logged in.
They did not.
And Your Honor, I have attempted to reach out to him there. I do have a number for the unit manager that I have left 2 messages for, and I have not heard back from that either.
We have to give them what?
4 weeks.
So why don't I adjourn this then today? Let me adjourn it to the July 23rd.
July 23rd, Your Honor?
Yes, sir.
Thank you, Your Honor.
Bond continue. That's all I have. But there's one recall.
Is it the last case? We can call it, Judge. We're ready.
Bless you. You're ready on it?
Yes, Judge.
Or you sure? Okay.
I think.
Court does call the case of the People versus Robert Show.
Assistant Public Defender Chandra Carey, can really, on behalf of Mr. Shellberg, Judge, can we approach?
You may.
Thank you, Judge.
I'm going to sign off for a little bit, folks. I got a little
All right,
urgency.
record should reflect
I
you
have
had a
to
bench
deal- I'm
conference
just
in
gonna
this
take
case.
off camera,
There's
but I'm
been
gonna
a
let
amended
this keep
complaint
playing,
filed,
okay?
which has
We'll
extended the
talk again
dates and
soon.
added
Thanks, guys.
a charge of witness intimidation, bribing. My understanding is the addition of that charge, there's no objection for the defense to that charge at this point. Not claiming that defendant certainly is guilty. Have no addition, no problem with the adding of that charge, correct? Excellent.
Correct, Your Honor, yes.
All right, and as to that charge, your client waives formal reading and stands immune.
He does, Your Honor.
All right, court will enter a not guilty plea as to that charge. requesting a preliminary examination. I will set a preliminary examination in both of these matters. Discovery being complete, but there is additional discovery, which are part of the phone calls that still have to come to defense as well as supplemental report. Everybody's aware of that.
That's what we've been told, Judge.
And I will set, and the people hopefully will have their witnesses available the 28th of July. Doesn't bear on the defendant's in custody status. So I'll set this for preliminary examination, July 28th, 2026, 9 a.m. That is before me.
If I may address that.
Man,
Since the court has revoked Shelberg's privileges, he has contacted the victim from other pins. There are 31 plea calls to the victim since he's been arraigned, and almost all of these calls would include things that would go towards this witness interfering or bribing, charge along with wrongdoing. I'm going to the joint jail that is taken care of. They're going to let me out if it's interested in me getting out. Otherwise, it's going for 7 to 10 years. He also has been instructing her on things to say, and that after those instructions, she reaches out to our office. He also has instructed her to contact the court's chambers to give them what he's telling her to say. He's also instructing her to try and visit him at the jail by using her sister's identity. I mean, the bond violations at this point are so flagrant, it's unbelievable, given that his privileges were revoked. He was told not to contact her. And in those original calls, they are also witness interfering, bribing, promises of marriage, promises of a better life, things like that nature. There's also, the court told him, no contact is no contact. He deliberately goes to other inmates' pins to continue that contact and continue forfeiture by wrongdoing type calls, instructions, contact, ways to get in contact around the phone calls, visits in person, telling her to come to court. And then after she's at court, set up a visit to meet with me at the jail. I mean, it's at this point, it's ridiculous, but I wanted to bring that to the court's attention, and it is the people's attention for the exam date to potentially have a motion for forfeiture by wrongdoing filed as well, given these calls and the tainting of the victim's testimony and the interfering with this criminal case.